On Friday, a lawyer you have never heard of signed 11 pages that moved one of the oldest lines in American law. The Justice Department's Office of Legal Counsel, the office that tells the entire executive branch what it may legally do, issued an opinion concluding that United States soldiers can arrest people just outside the militarized zones along the southern border, not on military land, outside it. The signature on the last page reads, William D. Hyde, Jr., Deputy Assistant Attorney General. Now, when this administration moves a legal line, my rule on this desk is simple. Never argue with the headline, argue with the document. So we pulled all 11 pages, and I read them. Tonight, what the opinion actually authorizes, the two words doing all the work in it, and the courtroom fact from last year that should keep this whole program's lawyers up at night. First, the machine as it existed Thursday night, because you cannot see what moved without the before picture. There is a law called the Posse Comitatus Act, on the books since 1878, and it draws a bright line. The military does not enforce civilian law on American soil. Soldiers are not police. That is the wall. The workaround, since last year, has been geography. The administration designated 6 so-called national defense areas along the border, in Arizona, California, New Mexico, and Texas, big stretches of land handed to Pentagon control. And on military land, the rules flip. Soldiers guarding a closed military reservation can detain anyone who enters it. That is not policing, the government argues. That is a commander protecting a base. Since April of last year, prosecutors have charged hundreds of people caught inside those zones, most commonly with 2 federal misdemeanors, violating a military security regulation and entering military property. Northern Command says its troops apprehend the trespassers and hand them to law enforcement. So the wall held, officially, because every arrest happened inside the fence. Keep your eye on that fence. Now, what Friday's opinion changed? Here is the operative sentence, exactly as written. In sum, we conclude that the use of military personnel to arrest trespassers just outside of an NDA would not violate the Posse Comitatus Act, given the express statutory authorization and the military purpose of a commander's traditional protective power. Just outside. For the first time, the government's own lawyers have said the arrest power crosses the fence line. But this is where you read the document instead of the headline, crew, because the opinion's own subject line is narrower than the coverage. It asks whether soldiers may make arrests outside, but within the immediate vicinity of a defense area, for crimes committed within that defense area. Parse that like a lawyer. This is about someone who allegedly trespassed inside the zone and slipped out before soldiers could grab them. It is a pursuit power, formalized. It is not, on its face, authority to arrest a person who never set foot in a zone. That distinction matters enormously, and the opinion holds it. What the opinion never defines is the other load-bearing phrase, immediate vicinity. No distance, no yardstick. 10 feet or 10 miles, the document does not say. And it notes the military may designate additional zones in the future, a boundary that moves, policed to an edge that is not defined. Now the counterweight, and it is a matter of court record. An opinion from the Office of Legal Counsel is powerful. It binds the executive branch's own conduct, but hear this clearly. It is a memo, not a court ruling. No judge signed it. Congress passed nothing. The line moved because the government's lawyer told the government it could move. And when these zone prosecutions have actually reached a courtroom, the record is not kind. In May of last year, the chief federal magistrate judge in Las Cruces, New Mexico, Gregory Wormuth, threw out the trespassing charges against more than 120 people caught in the New Mexico zone because the government could not prove they even knew the zone existed. These are stretches of desert, crew. Civil liberties groups have documented how poorly marked the boundaries are, and American citizens have wandered in by accident. So hold the full picture. The government claims arrest power inside the zones, has now extended it just past the edges, and a federal courtroom has already found that in more than 100 cases, it could not prove people knew where the zone began. Now soldiers may arrest someone outside a boundary that people provably cannot see, out to a vicinity no one has defined. Even Friday's opinion concedes every arrest must still survive, quote, the usual Fourth Amendment and other legal considerations. That test is coming. So here is the verdict, and what to watch. What happened Friday is real. The line between military power and civilian policing, a line this country has policed since 1878, moved outward over one Deputy Assistant Attorney General's signature, without a vote or a ruling. That is worth your full attention no matter where you stand on the border itself. But the document, read honestly, is narrower than the panic and bigger than the shrug, a formalized pursuit power, capped at an undefined vicinity, around zones the military says may multiply. 3 things to watch, crew. First, the first arrest made outside a fence line under this opinion, because that defendant's lawyer will put immediate vicinity on trial. Second, whether new zones get designated, because each one carries this new halo of arrest power with it. And third, the pattern. 2 days ago, I showed you a federal judge in Los Angeles poised to rein in warrantless immigration arrests on one coast, and the same week, this memo extends military arrest power on the border. The two tracks are headed toward the same question: who may put hands on a person in this country, and on whose authority? The documents are public. I read them so you start ahead. I'm Madeline, and this is Pixel Politics.